Good afternoon, everyone joining this webinar. This is Henrik Nordentoft. I'm head of UNHCR's Office for the Nordic and Baltic countries. I'm sitting here on a rainy afternoon in Copenhagen together with Nick Tan, who is a senior researcher at the Danish Human Rights Institute. And on the screen at the moment, you see some of the panelists that will help illuminate our discussions. It's really a pleasure for me to invite you to this webinar, which, as the title of the webinar says, will put a focus on the understanding amongst a broader set of interlocutors of the paradigm shift in Denmark and what implications that has had not only for the affected persons of this paradigm shift, but also wider for the European countries that may have seen some persons affected following that, and also from refugee policy generally. The very restrictive Danish policies and asylum is a long-standing phenomenon. I think they're well known to many of you who are joining us. And in spite of the very low number of asylum seekers over the last 5 years, an average, I think, of around 2,500, evolution in Denmark has been covered extensively in the press, in the media, and so on. So I think many of you are familiar with Denmark and restrictive policies. But what we really are focusing on in this webinar is the paradigm shift that was adopted in 2019, adopted with a very broad consensus in the Danish parliament. And in essence, the paradigm shift, although you will hear more about it, is really an orientation towards a focus away from long-term integration and seeing protection and refugee protection as a solution, but more towards an emphasis on earliest return and temporariness of the protection arrangement. So indeed, a significant shift in terms of the implications. There is another angle in Denmark, as you may know, and that is about the Danish discussions on an externalization arrangement. This is still a project. It's not like in the UK. And just to say, this is not what we'll be covering this webinar. That is already discussed in other places. Here we will focus on the temporariness of and the paradigm shift. Just very briefly to say in terms of UNHCR that we have been quite worried for the tendency of introducing temporariness and linking that to refugee protection. Not that refugee protection needs to be forever, but that temporariness is instituted or installed a new uncertainty and anxiety, especially when coupled with very short-term residence permits and so on. So we have always advocated that refugees need a stable and secure residence status, and that one only should review and the refugee status for secession purposes under those conditions in the convention, while the shift seems to be a much more periodic and earlier understanding. Both the Institute of Human Rights, Danish Institute of Human Rights, and my office, as well as many Danish NGOs and researchers like Jens and others, have received numerous requests over the last 12 months, 18 months about better understanding. That's really what created the feeling that we needed to reach out to you. And also we felt that it was important to have a broader discussion, not just a national discussion, but one that involves others to inform, reflect together with us on this. We have a great panel of speakers today. I'll introduce them in turn as you see them, and they will cover the different dimensions as we are covering the area. So we'll hear more on the paradigm shift itself, trying to understand the history around it and where we are. We'll hear about the human rights dimension of temporariness and revocation of states from Nick. We will hear how it has affected persons of concerns, those who have been targeted. Mahmoud will help us with that. We'll hear broader already, then going outside Denmark and listening to Jessica, looking a little bit about how it has also played in across areas in other parts. And we'll listen to Mark, how he has seen and encountered already a situation in Holland into absorbing an implication of temporariness in one European country. So I think we'll have really all the dimensions covered. And we look forward, of course, to all of you reflecting on it. Just two practical announcements. There will be a Q&A for about 30 minutes at the end. It will be, as it's a Teams call, you can raise your hand. At that time, we will select a few and you will go on video and just ask your question. And we'll hope the panelists can do that. We hope to get 6-7 questions in. So be sure and be short when you ask your questions. That's one question. The chat function is open, and you're most welcome to pose a question in the chat function and to post a resource or a document or something you feel is of interest to all. But please, could I ask you to refrain from starting a chat discussion? I've been in many webinars where it looks like the chat discussion is overshadowing the webinar and the presentation. So if those of you who are very interested in debate selects another time for doing that, find a friend to do it later on, but please, let's try to listen on the webinar on this one here. With all that said, I think, Nick, we're good to go. And in the interest of time, then it's my privilege to give the word first to one of the grand old men of Danish asylum law and asylum policies, a researcher, Jens Vedsted Hansen. He's a professor of human rights law at Aarhus University in Denmark, and his current research focus is primarily on the EU asylum governance and on temporary refugee protection within the asylum and temporal projects, respectively. And Jens, you have promised us to enlighten our participants a bit on the history of the paradigm shift and on where we are and what it is. So over to you for that.
Thank you very much, Henrik. And indeed, thanks to both of the organizing institutions and personally to Nick and you, Henrik, for drawing attention to the still increasing dilemmas caused by the paradigm shift, as it has been illustrated by the report recently launched by the Danish Institute for Human Rights. In the English version, You Can Never Feel Safe, as well as the report Anatomy of the Paradigm Shift Towards Temporary Protection in Denmark, which was produced mostly by me as part of the temporary research project. While Nick will identify the human rights law issues arising from revocation processes that have been fortified by the paradigm shift, and Jessica and Mark will widen the perspectives beyond Denmark, I shall give a brief account of the evolution of the so-called paradigm shift. I'll suggest three aspects of this evolution. First, the initial policy of securing a more or less permanent legal status for refugees. Secondly, the emerging or evolving temporary protection arrangements as crisis measures, and then thirdly, the current revocation policy and practice. First, a brief historical overview. It has, in defense of the paradigm shift, been argued by certain politicians, I think even by the former Danish immigration minister, that it was never intended that refugees should remain for permanent protection in Denmark. Formally, this might arguably be considered in line with the principle underlying the cessation clauses in Article 1C of the Refugee Convention, even though I don't think that was actually what the minister or other politicians were alluding to. I would therefore rather posit that this is an inaccurate statement of Danish asylum policy, which has, at least since the 1983 Aliens Act reform, that is 40 years ago, been based on the opposite actually. Initially, the revocation of asylum residence permits was possible only for an initial period. From the very beginning in 1983, it was actually 2 years. Then it was extended, and now it's normally 8 years, sometimes less than that, until people get permanent or can hope to get permanent residence permits. But indeed, there was a very short window of revocation in which you could sort of apply the cessation clauses. The second feature of the 1983 reform was actually, as it still is, that unlimited cessation and revocation can only take place in mass influx situations, which have formally never taken place so far in Denmark since 1983. Instead, it was actually the intention to offer refugees a secure legal status with the prospect of permanent residence and with a view to naturalization under certain ever more strict conditions, of course, which is indeed well in line with the durable solutions foreseen in international refugee law and policy. So much for the initial policy objectives. Then my second focus will be the introduction of temporary protection as a crisis response. Indeed, the first measures towards what was explicitly termed temporary protection was special legislation for the Bosnian and Kosovo refugees in the 1990s. And here it makes sense to term this as a crisis response. There was a kind of dual rationale in this. One was to provide collective protection outside the ordinary asylum system. And secondly, the purpose of this was actually to enhance protection capacity. This was most prominently sort of presented as the policy rationale by the then Norwegian minister responsible for refugee protection, but it was underlying also the Danish and I think the wider UNHCR-sponsored approach to the protection of the Bosnian refugees. More recently, we have seen what in Jessica's project Tempro is often referred to as the return turn in asylum policies, not least in Denmark. This is an emerging temporary protection regime which is sort of becoming the new normal. It has been introduced in Denmark in two stages, which more or less reflect the two steps in the individual decision-making process. First, the review of protection needs, and secondly, the balancing of integration factors and perhaps family life against the application of the cessation rules. The first stage was in fact introduced in Danish law in 2015, where temporary protection status was adopted by way of Section 7.3 of the Aliens Act as a kind of tertiary protection status, substantively closely linked to subsidiary protection, referring to Article 3 of the European Human Rights Convention and similar human rights standards, but targeting situations of generalized violence and human rights violations. That was the one purpose of the 2015 reform, what was sort of attracting most attention, I guess. The second one was actually, importantly, that the threshold for revocation or refused extension of residence permits for holders of subsidiary protection and the new status, temporary protection status, that threshold was significantly lowered. This was in fact the first stage of what is today known as the paradigm shift. But the term paradigm shift was only officially proclaimed in connection with the 2019 legislative reform, which has different features. I guess the most important among them are that all asylum residence permits are now being issued for temporary stay. Now there is a system of mandatory application of the revocation or non-extension rules. And thirdly, the impact of integration has now been limited to the minimum level mandated by international obligations, especially Article 8 of the European Human Rights Convention. This is the second stage of the decision-making, which Nick will explain in a few minutes. Now, we could, of course, discuss whether the current temporary protection regime in Denmark is to be seen as crisis management. When temporary protection status was introduced in 2015, that was actually before the outbreak of the 2015 asylum crisis, and it was not formally linked to a crisis, although reference was made to increasing asylum arrivals. In any case, there was a clear intention to expand the scope of revocation of residence permits for subsidiary protection and temporary protection status, as I just mentioned. And there was also from the very outset a significant reduction of some core rights for holders of temporary protection status, in particular family reunification rights. Therefore, although there was no explicit crisis link in the initial or the first stage of the return turn, there was still a sense of connection to the what became the 2015 asylum crisis. Later on, when the suspension of family reunification for temporary protection status holders was extended to 3 years in 2016, there was a very express deterrence objective, and the wider context was simply deterrence. It was meant to make Denmark remarkably less attractive as an asylum country. That's almost direct quote from the travaux préparatoires of this legislation. So the conclusion is, I would say, that altogether, the two stages of the return turn, which was finally in 2019 coined the paradigm shift, must be seen as measures towards deflection of protection responsibilities. My third focus will be a brief account of the current revocation policy and practice. Once again, revocation technically in Danish asylum law equals non-extension of asylum residence permits. Often they are allowed to expire and then just extension is refused rather than interfering during the existing period of a valid residence permit. These periods have been made very short, so there's no reason, you could say, to actively revoke, because you can just wait and see once the extension is going to be decided. Then in law and or policy, we have seen that administrative practices have been heavily exposed to politicization in various manners. This, I think, applies both to the first step of the decision making, the review of protection needs, and also to the second step of the decisions, the balancing against integration factors. I'm just saying a few observations on the review of protection needs under Article 3 of the European Convention or similar human rights provisions. Here it was remarkable that the Refugee Appeals Board, on its own motion, signaled that now there was a change of circumstances in parts of Syria, in Damascus, which might make it relevant to reconsider the grant of temporary protection status. That was very, very unusual for a quasi-judicial board to actively promote a review of practices. Secondly, the Immigration Service immediately followed up, actually issued a press release on the very same date in February 2019 as the Refugee Appeals Board had sent out its signals. One might suspect there has been a kind of coordination, right? Thirdly, when then the Appeals Board was reviewing or examining the first 6-7 test cases in June and September 2019, it took really a very cautious approach and did grant asylum with normally a more secure status to all of the applicants. However, during 2019 and 20, the practice was gradually shifting, and that resulted in a political push in June 2020, where the Minister of Immigration requested the Immigration Service to initiate what was later termed the Damascus Project. And that has then, of course, sent a lot of cases for review in the Refugee Appeals Board, where we have seen during the past 1.5 years, I think, increasing disparities in practice between the Immigration Service and the Refugee Appeals Board. Some of these disparities can have good reasons, such as occurrences in individual cases between the two stages of the decision. There are indeed some surplus elements in a number of the cases as well. But it also seems that the two bodies have different approaches, either to the assessment of the protection need or to the balancing against integration factors and family life. Altogether, I would conclude that the so-called principle of caution officially proclaimed by the Refugee Appeals Board has been a bit difficult to come to terms with. It has either been vanishing or shifting, and perhaps more recently it has been reinforced. It's hard to say, but we are, I think, in a very sort of challenging situation as regards the practices of the Appeals Board these days. Thank you for your attention.
Thank you. Thank you so much, Jens, for in a way trying in a 10-minute window to summarize your report as well. And just to highlight to all participants that Marie Yule posted the report, which is a longer version to, in a way, that those more interested in further details can look at. So that's a long report. Thanks, Jens, for that. Really very helpful. As you said, Jens, there's a natural link to look now at revocation and then the whole question of the human rights perspectives and revocation and what it means. So I'll hand over to Nicholas Tan, who is a senior researcher here at the Danish Institute for Human Rights, and he specializes in asylum and refugee law. Nick, over to you.
Thanks so much, Henrik, and a real pleasure to be co-hosting this important event with you today. And thanks, Jens, for this really important and I think concise sort of recent historical but also contemporary account of the paradigm shift. So what I want to do today is draw on this recent report, which has been mentioned. You Can Never Feel Safe. It's out in English online. And I want to hone in, as Jens has mentioned, on some of the human rights law challenges we've seen connected to the paradigm shift in general and revocation practice in Denmark in particular. And while Jens has addressed some of the Article 3 issues around the security situation in Syria, I want to focus on questions much closer to home around, well, what value does integration have as a matter of human rights law in the Danish paradigm shifts? And I'll do this in 3 ways. Firstly, I'll set out the contours of the right to family and private life under Article 8 of the European Convention on Human Rights, which many colleagues will be familiar with already. Secondly, I'll highlight some of the legal and procedural challenges that we have seen in our research with respect to how Denmark is implementing its Article 8 obligations vis-à-vis Syrian refugees. And finally, I want to draw out less legal experiences, but more common subjective experiences of the paradigm shift and of the revocation process that we've seen when interviewing Syrian refugees. Before I do that, though, in very concrete terms, the paradigm shift with respect to Syrian refugees in Denmark has resulted in the assessment of around 1,100 refugees, mostly from the Damascus province, with, again, around 130 final decisions of revocation. And that's including where we see people moving on to other EU countries, as we'll hear about. So let's just set the scene with regard to human rights law in this area. As many of you would know, Article 8 of the European Convention protects the right to family life for settled migrants, irrespective of their migration status, and therefore allows for what I call integrative links in Denmark to be considered. However, of course, Article 8 is not an absolute right. The state may legitimately interfere with this right where such interference is in accordance with law, pursues a legitimate aim, and is necessary in a democratic society. So what this means, in essence, is that the Danish authorities are conducting a balancing assessment between the interests of the state on the one hand, in this case to control migration, and the interests of individual refugees who may have resided in Denmark lawfully for 6, 7, 8 years. Now, as we've heard briefly, under the paradigm shift, only Denmark's international obligations, and in particular Article 8, set the limit for when revocation can occur and when it cannot. In other words, in the Danish Aliens Act, a refugee's residence permit must be revoked unless this would breach Denmark's international obligations. Now, criteria such as the duration of residence and in particular children's attachment to Danish society do play a role in revocation procedures, but we would say to a lesser extent than previously. And as a matter of law, a refugee's attachment to the labour market and Danish language skills, for example, shall be given the least possible weight. This means in practice, of course, that a refugee's residence permit may well be revoked, regardless of the fact that he or she has a high level of degree of attachment to Danish society and is rather well integrated. So to move then from the human rights law challenges, what are the challenges we see as a matter of practice? So we, in our report, identify a range of both substantive and procedural problems. First, as a matter of law, we find it problematic that the Danish revocation practice is essentially based on practice from the European Court that relates to the expulsion, not of refugees, but of criminal foreigners. And in essence, there is no comparable practice with regard to refugees from the Human Rights Court here. We also think there's a general lack of clarity with respect to the criteria used in revocation practice, and we find that the Danish Immigration Service, that is to say the first instance, tends not to give due weight to family and private life. And here they do so, we think, in 2 particular scenarios. The first is where you have parents and young adult children. So you might think of, for example, a 20-year-old young woman from Syria who loses her residence permit, notwithstanding what she would see as strong family ties here in Denmark with parents residing in the country. The second is the assessment of children in families, where in some cases we see, a teenage child in a family who's been in Denmark for 6 or 7 years, goes to school, plays at a sports club, etc. In some cases, that child will retain their residence permit. In other cases, they will lose it. And from a more practical perspective, we find that authorities' guidance to Syrian refugees in the revocation process is often inadequate in crucial respects. This means there's a high rate of rumour going around in community, a risk of lack of knowledge or understanding of the processes involved. And as we've seen, and we'll hear from Mark, some refugees have indeed given up prematurely and moved on to other European states. Finally, in my brief intervention, I'd like to speak to what our research shows about how Syrian refugees themselves experience the revocation process. In general terms, of course, the paradigm shift that means that many refugees in Denmark live today in conditions that are characterised by much higher degrees of temporariness and uncertainty than before the shift. For refugees trying to integrate in Danish society, of course, the process of revocation is particularly intrusive because it basically puts lives and futures on hold. If you lose your residence permit, you lose the right to live in Denmark and to work in Denmark, and you risk separation from family. Crucially, I think our research also shows that irrespective of the outcome, that is whether a person can remain in Denmark or whether they lose their permit, the process itself is intrusive as such. It's protracted, it's stressful, it has mental health and other implications. A few themes that arise from our research. Firstly, the detrimental impact on quality of life and mental health. Secondly, separation from family and risks or concern about family groups being broken up. Thirdly, impact on work and educational opportunities and choices that refugees are making. And finally, a significant lack of trust in the Danish authorities as a result of a sense of being misled from the origins, as Jens mentioned, of protection in 2014 and 15 to being faced with a risk of revocation in 22 or 23. And no doubt Mahmoud will expand and elaborate in much more detail on these experiences. My final point for you today is to look to the future very briefly, and that is, of course, that the Denmark has a new government, and that government is settling in now. And there are early signs that that new government will try to carve out some exceptions to the paradigm shift. The new government agreement states that where a Syrian refugee is studying in an area that is where there's a shortage in Danish society, they'll be able to retain their residence permit. However, at this point, we don't know what the extent or scale or implementation of these exceptions will be. I'll stop there and look very much forward to our discussions. Thank you.
Thank you very much, Nick, for those words. In a way, we have now gone through a bit the policy framework on the paradigm shift. We have looked at the human rights dimensions. But importantly, I think you provided a segue to that. We now look in a way at the human impact. And I'm so pleased that we have with us Mahmoud Almo-Mahat, who is a medical student here in Denmark. He's lived in Denmark for 7 years. He's from Syria originally. He's also a human rights activist, and he's been very active in this public debate in Denmark around pointing out exactly some of the aspects that you have mentioned, including himself, that his parents have faced the threat of revocation and return to Syria. So Mahmoud, so pleased that you're with us today, because it's such an important voice for everyone to understand what's going on and to speak that from your own experience within the Syrian refugee community. So over to you for your reflections to all the participants listening in today.
Thank you. Good afternoon, everyone. It's a pleasure to be with you today, and I'm grateful to have the opportunity to share my story with you. 12 years ago, a war broke out in Syria. Over 13 million people were displaced. Neighboring countries, Lebanon, Jordan, and Turkey, took in over 5 million Syrians, but they could not accommodate everyone, so many had to flee further. My family and I arrived in Denmark in December 2015. I will never forget our escape and the journey across the Mediterranean in a small rubber boat without life jackets in the middle of the night. We were so scared, but we had to do it. And trust me, No one puts their children in a boat unless the water is safer than the land. Fortunately, we survived, unlike thousands of others who didn't. We went up through Europe to Denmark, where my sister already lived. Finally, the family was reunited and safe, but our safety did not last. In 2019, the Immigration Service began reassessing the Syrian cases because they believed Damascus and Reef Damascus were safe. And because my family comes from Damascus, the whole family was summoned to interview at the Immigration Service in Copenhagen. My older brother and I had turned 18 then, so we were granted a residence permit because we were of military duty of the age in Syria. And if you were sent back, we would have to join the military, which I would never accept. I would never help kill my people in Syria. The rest of the family was allowed to stay in Denmark, except for my parents. The Immigration Service believed that it was safe for my parents to be returned to the Assad regime, while it was dangerous for the children. I couldn't believe my eyes when I read the decision. Is it safe for my parents to return to some dictator they fled from a few years ago? The Immigration Service thought so. They were to be deported to Assad, but since Denmark had no cooperation agreements with the Assad regimes, they were not forcibly deported. Instead, they had to sit in a deportation center called Sjælsmark for an indefined period until they chosen to return to Assad or until Denmark can come up with and cooperate with Assad's regime. My parents was taken from us and almost buried into Sjælsmark, which was similar to a prison with fences all around. After a long and hard month of Sjælsmark, my parents' case was reopened, and fortunately they were gained again a residence permit. They got their rights back. But my parents are not the only one being told that they should be sent back to Assad. Almost every day we hear about Syrian refugees losing their residence permits, many of whom are young Syrian women in the labor market and enrolled in education. They pay taxes and contribute to society just like any of us in Denmark. It is so crazy that the Immigration Service believes that, on the one hand, that we should protect their brothers and parents, and the other hand, they should be sent back to Assad. And of course, these well-integrated young Syrian women will not return to Assad. When they do not do it, they will be taken out of their communities and placed in Sjælsmark or another deportation centers under very bad conditions where they will lose their education, jobs, and not at least their rights, which is not fair. Since 2019, many Syrians in Denmark have not lived in safety. We live in constant fear of being sent back to the same regime from whom we fled. And many of us have had our residence permits revoked and must be sent back to Assad Syria because Denmark is the only country in the EU to assist Syria as safe. Denmark believes Syria is safe, even though the EU, the UN, and Amnesty, Human Rights Watch, and even the Danish Refugee Council have documented that returning refugees are subjected to torture, rape, and imprisonment. Finally, I would like to thank you and everyone who chose to support the fact that my parents and other Syrians are not being sent back to Syria because Syria is not safe under Assad's regime. Thank you very much.
Thank you so much. Thank you so much, Mahmoud. Really a telling illustration of, I think, what you all have heard just prior to this. indeed fitting into exactly what Jens Visted Hansen was mentioning, that there was a practice by the asylum first instance to revoke, and then, as you said, thankfully, we're very happy to hear that your parents made it in the appeal, but the psychological impact, as you said, and the anxiety and the nervousness, how that has caused you and your parents must have been tremendous. And just in general, for those joining us today to know, this revocation practice has primarily affected elderly people and young female persons within the families and broken up families. So we have had almost all histories like yours, which is that all men in the age of 17 to 45 have been considered obviously in need of protection, but then their families and fragments have not, regardless of whether these persons have been in Denmark for many, many years. And that's one of the perverse, effects of what is happening, in a way of not considering everyone together as a joint family. So thanks very much, Mahmoud, for joining us with that. I think this transition is important for us because now we're also talking about what has been the implications for this policy. This nervousness has been created. And as Mahmoud mentioned, Denmark has been one of the only countries applying the ending protection for Syrian refugees, of which there are 7 million around Europe. And therefore, Denmark really has gone it alone. In order to illustrate how this now has spread, and that's the dimension of the implications beyond Denmark's border, we're now moving to, and with a great pleasure, introducing Mark Weingarten, who is a Dutch lawyer. He specializes in criminal law, immigration law, and asylum law. And many of his cases are transnational, crossing international border. He's a member of the Professional Associations for Criminal and Immigration Lawyers, and he's also regularly giving courses for those lawyers. Today, he's not giving us a course, but hopefully he's giving us very valuable short input on what you have experienced, Mark, in Holland, with regard to the effect of what has been happening in Denmark and your reflections on that. Over to you, Mark, and thanks for joining us.
Thank you, Henry. I'm happy to take over. The effect of the policy change in Denmark has obviously been that the Syrian refugees from Denmark have been coming to the Netherlands because they were losing their right to residence in Denmark and were in fear of being returned to Syria. We're not talking about very many people. I've looked at the only available source for this information, Eurostat, and that suggests that several dozens of people, or a couple of dozens of people, have fled from Syria to, from Denmark to the Netherlands, because that's about how many claims the Netherlands has laid on Denmark for, as far as we can see, Syrian people. Okay, a short introduction. We all know, I think, by now what the policy for Syrian refugees in Denmark is. It's quite different in the Netherlands. After an investigation by the Dutch foreign ministry, I should say, it has been assessed that the risk of arrest, detention, disappearance, torture, and even death for a Syrian national on returning to Syria, if he or she is not a clear supporter of the Assad regime, that risk is completely arbitrary, and it's impossible to say who will be arrested, detained, etc., and who not. For that reason, and because the risk of detention, etc., is too big, the Dutch policy is that every Syrian national who returns to Syria runs a risk of inhuman treatment, persecution, etc., and is entitled to international protection. The situation where one member state of the European Union offers less or more protection to refugees than another member state is not new, and it has caused quite a lot of jurisprudence in the Netherlands. As a matter of fact, the European Court of Justice at this moment has several questions from at least one country, Italy, about the difference in policy, in protection between Bulgaria and Italy. The most recent and also most defining decision by the highest court in refugee cases in the Netherlands, the Administrative Jurisdiction Division of the Court of State. The last decisions are from the 6th of July last year, and that concerned 3 people, 2 people from Denmark and 1 person from Sweden, who had left those countries and came to the Netherlands because in those 2 countries the policy is that for some areas and some people, like elderly people and women, the province of Damascus in Syria is safe and people can actually return there without a risk of detention, etc. Now, normally the Netherlands says that because of the Dublin regulation, there is an interstate trust principle, so that anyone who has been sent back to Denmark or Sweden, it can be relied on that they will not be sent back to Syria because of the risk, according to Dutch sources, people run there. But at this point, these procedures, it was clear that the policy and that the level of protection offered by Denmark and Sweden is quite different from the level of protection offered by the Netherlands. And the question was, how does the Netherlands deal with that? Is the principle of interstate trust predominant, and does it push aside all other facts and things? Or should the Dutch administration consider the difference in the levels of protections? The decision that was published is quite clear on this. It first says that the starting point of of the judging of every application in Dublin situation, so to say, still is that the interstate principle of trust has to be relied on. Only if the asylum seeker can prove that in the other country evident and fundamental difference in the level of protection offered to people from a certain country through a certain group of refugees, only then the principle of interstate trust may not justify the transfer of these people back to, in this case, Sweden or Denmark. But this is not the only thing that the asylum seeker has to prove. There has to be more than an evident and fundamental difference in the level of protection. The asylum seeker has also to prove that the courts in those other EU member states agree with the different level of protection offered, and that they will not prevent that that member state to send people back to, in these cases, Syria. If the asylum seeker manages to fulfill this burden of proof, proving that there is an evident and fundamental difference in policy, and also the courts in the other member states allow this, then the burden of proof shifts to the member state, in this case the Netherlands, and which has to prove beyond any doubt that when somebody is being transferred to the other EU member state, that there is no risk of refoulement, that there's no risk at all that these persons will be transferred on to Syria or another country where they run a real risk for persecution or serious damage. One of the problems in this procedure was that at this moment, Denmark actually does not deport people to Syria because there are no diplomatic relations. That was one of the points that the Dutch state brought forward. And the Dutch state also said that by the time these people are deported to Syria, they can always address the European Court for Human Rights to stop that. This was rejected by the Dutch Court of State. It said more or less that if you force people to wait without a procedure until the very last moment when they are going to be deported to Syria, first of all, you are not sure if they have enough time to start such a procedure. And second, having to wait in such a situation, waiting for your deportation until the diplomatic ties have been reopened, and waiting for a moment that you can start a procedure with the European Court of Human Rights will put people in such a stressful situation for such a long time that it is not to be considered an effective remedy. So the fact that people can complain in Denmark against deportation, I should say, to Syria is not a reason to say that we can still rely on the principle of interstate trust and send people back to Denmark. To conclude this, both Danish cases, so to speak, there are of course also Syrian cases, both Danish cases were won by the asylum seeker. The Swedish case was lost for quite a simple reason. The person in Sweden had waited for a rejection of his asylum application, but did not take the case to court in Sweden, but came to the Netherlands right away and applied for asylum here. So when the claim was sent to Sweden and Sweden accepted that, the person could prove here in the Netherlands that Sweden has an evident and fundamental different level of protection for Syrians, but he could not prove that the courts in Sweden would not protect him against refoulement. In other words, that the courts in Sweden did not defer with the Swedish policy. And for that reason, this person had to go back to Sweden and probably take his case to court before he would have the opportunity to apply for asylum in the Netherlands again. Both Swedish persons, one of them, the leading case, was my client. The verdict was from the 6th of July last year, which means that 6 months plus 6 days ago, the verdict came. And 6 months, they have not tried to transfer her to Denmark. So according to Article 29 of the Dublin regulation, now the Netherlands are responsible for dealing with her asylum application. And according to the Dutch policy, still, she will be given asylum status without any doubt. Thank you very much.
Thank you so much, Mark, really for giving us these insight, very helpful for everyone to understand. I think you just give an illustration from, of course, one European country, but we believe that there are similar examples in other European countries. Obviously, we do see that the total number of Syrians that have left either after having lost a case of relocation or in anticipation of an anxiety of risk of losing it may be in the neighborhood of 500 to 700 persons, but it's unsure the numbers. But it's very important, as you say, to see what is happening with regard to the state practices and so on. And it plays in, of course, this understanding, and we're moving to the next segment, and you provided a perfect segue to Mark to that, which is what does a national policy in one country meet to a policy in another country? Meaning, how do we have a European harmonization, and what are the impacts beyond borders of what is happening? In order to speak to that last dimension, before we move to some questions and some further elaborations, is Jessica Schultz, who is just joining us on the screen now. Welcome, Jessica. She's a senior researcher at the Christian Michelsen's Institute in Bergen, Norway, where she's working on global refugee law and policies. Her current research, very appropriately for this seminar, focuses on temporary protection and the relationship between vulnerability and protection with the whole asylum governance in Europe, which therefore is of great interest to us. And I understand you're also currently the lead researcher for the TEMPRO project, which I believe stands for Temporary Protection Project, which explores those practices in Norway comparatively with the UK, Denmark, and Germany. So we are all ears to hear what you have to tell us, Jessica. Over to you.
Thank you, Henrik. And thank you both Henrik and Nick for the invitation to be here today. In this presentation, I will be discussing how strategies pursued as part of the paradigm shift in Denmark, namely temporary permits and cessation practice, are implemented elsewhere in the region. Because of our time limits and also, frankly, limits in my own expertise, I'll be focusing on findings from the TEMPRO report on the temporary churn in asylum policies in Norway. It looks like this, and you can find it online. And more superficially touch on developments also in Sweden. I see that there are some experts in Swedish policy participating in the seminar today, so hopefully they can elaborate more in the discussion. But in Sweden, as many of you know, the new government has announced its own kind of paradigm shift, inspired by Danish example. I also wanted to mention that we've done a recent report on temporal asylum governance in the UK, which I'm also happy to talk about during the discussion time if there's interest. So my comments focus on 3 strategies to reduce the security of residents we see being deployed in Denmark, and think about the ways in which they are applied also in Norway and to a certain degree Sweden. These include, first, the introduction of new and weaker categories of protection. Second, the intensification of cessation and revocation practices. And the third strategy is relates to sharpened requirements for permanent residents. The first strategy relates to what Roger Zetter refers to as bureaucratic fractioning, or the creation of new migrant categories that enable more temporary protection with fewer attached rights. So what we see in Denmark with the introduction of the tertiary protection category that's been applied to Syrian refugees is a good example of this. Norwegian law, by contrast, currently extends refugee status both to refugees who meet the convention criteria and to refugees protected from return under Article 3 of the European Convention on Human Rights. In other words, there has been no subsidiary protection status in Norway since the introduction of the current Immigration Act in 2008. There have been several efforts, particularly after 2015, to introduce a subsidiary protection status, which would involve a limited right to family reunification and extended use of temporary permits. This has been reiterated as part of the current government's platform, and a new legislative proposal is under development. So we are likely to see this change happening. But I would say that this kind of bureaucratic fractioning has not so far been a strategy that's pursued as part of Norway's sort of restrictive response to high numbers of refugee arrivals. In Sweden, meanwhile, the majority of refugees receive status under the country's existing subsidiary protection legislation. In 2016, the duration of residence permits for this category was reduced to 13 months, while people recognized as convention refugees are granted permits for up to 3 years. So this is in contrast to the previous practice of granting permanent residence immediately to both groups. When it comes to family reunification, authorities will determine whether the sponsoring refugee has good prospects of being granted continued residence once their initial permit expires. And the new government's platform intends to limit this even further. So while we don't see a proliferation of new protection categories in Sweden, we definitely see strong trends towards the fragmentation of rights within them. Moving on to cessation and revocation. As in Denmark, application of the cessation provisions embedded in the Immigration Act is now mandatory in Norway. The awakening of cessation practice happened similarly in the autumn of 2015 as part of a broader package of asylum restrictions. The mandatory practice relates both to cessation on the grounds of changed circumstances in the country of origin and cessation based on a person's voluntary reavailment of home state protection. Articles 1C 1 through 4 of the Refugee Convention. There's only been one national group so far targeted for cessation practice based on changed circumstances, and that is refugees from the Mogadishu area in Somalia, who in 2016 faced sort of a reopening of their cases. They received notice, in fact, that their cases would be reviewed. And the vast majority of these ended up getting just sort of set aside because it was clear that the person would have other grounds for residence based on, for example, the risk of FGM, forced marriage in Somalia, family members in Norway having Norwegian citizenship or permanent residence, or a child's length of residence in Norway. And since then, there hasn't been active cessation practice directed at a particular group. However, the enhanced focus on controlling possibly fraudulent claims for refugee status is arguably more significant than cessation practice in terms of its capacity to create insecurity in refugee communities. It is not always clear to refugees themselves what the rationale is when they receive a notice that their case is being reopened. We have an example. In our own research, one of our informants is a Syrian man whose application for permanent residence has been on hold for over 4 years. And the reason he told was that the immigration director received a tip. He had a second passport and was traveling back to Syria in violation of the terms of his asylum. So here it wasn't clear whether he was suspected of a fraudulent claim or fraud in the original asylum claim, or whether it was a cessation case because he had voluntarily reavailed himself of Syrian state protection by returning there. In any case, this tip was never verified. It wasn't true, and the consequence for the person was 4 years of limbo. His documentation was with the Immigration Directorate. He couldn't travel outside of Norway at all. He couldn't meet his daughter. He struggled to sleep, continue Norwegian courses, and so on. In Sweden, meanwhile, the group-based cessation practice has so far not been a priority, although renewal of permits implicitly involves an assessment of continued protection needs. However, the new government's platform promises that residence permits will be followed up regularly and will be revoked if the original basis for asylum no longer exists. So again, we've seen a sharpening of the rhetoric there. And then finally, the third and related dimension of this sort of temporary turn is the sharpened requirement for a secure residence status. In Norway, this has involved a number of strategies. The first has been to extend the initial period of temporary residence for all refugees from 3 to 5 years. And since cessation practice only applies to refugees with temporary residence, this essentially means that refugees are exposed to the threat of cessation for a longer period of time. The second involves the intensification of requirements through which immigrants must earn their right to permanent residence, and the most significant was a new income requirement for permanent residence implemented in 2017, which in 2022 amounted to about 280,000 Norwegian kroner a year before tax. So that's quite significant. Another is the sharpening of the language requirements, also in 2017, from a duty of attending courses to achieving a certain level of language proficiency. And although these screening mechanisms apply to all immigrants and not generally linked to return objectives, it's significant that several were introduced in late 2015 as part of broader efforts to make it less attractive to apply for asylum in Norway. In Sweden, briefly, refugees must have residence for at least 3 years, meet an income requirement, and be expected to live an orderly life. And the new government has proposed a sharpening of these requirements as well. So to conclude, I would say that while Sweden is more explicitly taking cues from the Danish paradigm shift, in Norway, the effects are more diffuse. On the one hand, the government has signaled the introduction of weaker protection regimes, but on the other, interest in group-based cessation seems to have waned, at least for the time being. An important finding from our ethnographic research, though, is that the experience of temporary protection is produced through entanglements of different policy areas, not only in the field of asylum. So while some Syrians in Norway do worry about a possible change in policy regarding cessation along the lines of that pursued in Denmark, their more immediate concerns center on the racialized impacts of the integration policies that narrow access to permanent residence and limit economic and physical mobility. In other words, as some of our informants have described it as being sort of a second-class citizen of or unwanted in Norwegian society. Thank you.
Thank you so much, Jessica, for giving us that perspective on comparative analysis of the countries. And you said you have more on the UK study as well, if there is interest amongst those participating. Thank you then to all the panelists. We managed it within 60 minutes. That's a first for the webinars I've attended. We actually stuck to our agreed 30 minutes for Q&A. We are all on a huge Teams call, and the way we suggest that you are welcome and invited to ask questions is to raise your hand in the traditional way, just to do that. We are particularly interested also to hear maybe from practicing lawyers and civil society groups in other countries than Holland, for instance, just to explain and add further to Mark's, but also any questions that you may have to further understand what has been put forward here and any questions that you may have. So could you just the people there? So let's just see whether there are any questions, and I'll group them. And when you do ask your questions, please do just cite your name, but also where you are as concise as possible. As it's difficult to monitor all the hands coming up, just strange on the hand. Let me just see whether one of you can turn on your camera if you want to ask a question, if that's possible. I'll have to ask the web organizer here whether that's possible at all. I'm not 100% sure. Seymour, just go to Seymour.
Yes, I think I can unmute people.
You can unmute people. You have the power to unmute people. That sounds good, Mary. That's a fantastic power to have in today's world. Then if you can unmute the ones you can see asking us questions, and please go ahead, Marie.
But problem is I cannot see who is raising their hand for some reason.
It could be a result of the function. Just checking whether that works at all. Are we sure that we actually can get, sorry, I saw my colleague Anders, Sarah there. So Sarah has raised her hand. Sarah Tansey. Sarah, can you turn on your camera? Thank you for being the courageous first one volunteering. And if you can unmute her camera, unlock her camera, Mary?
Yes, done.
It's done, so we should see her appear. Thank you, Mary, for doing that. Aha. I can't turn on my camera or so on you to tests. So Sarah was trying to help us there, Mary, but there seems to be a challenge.
Oh.
Try to go to Sarah Tansey there, at one up. Allow mic.
Yeah.
Allow camera. Sarah, would that work for you now or not? Sarah Tansey, we're just trying to unlock your mic and camera. Would that work for you? I guess it comes back again. Right?
Hi, yes, it does work for me now.
Fantastic, Sarah, good. So it does work, so that's great to see. So
I just wanted to test if the hand raising function worked. I don't actually have a particular question other than just wanted to see if I could help nudge things along for the group.
Thank you. You're very helpful in at least proving that it works. So then I invite other colleagues just to raise their hand and flag their interest to raise a question. Otherwise, I'll start with one, if you don't mind. Jens, it's just first one, a question to you to make sure that we have a clarity on, you referred to the very important dimension, the paradigm shift from 2015, which was indeed the lowering of the revocation criteria, which, first of all, it is a criteria that is applicable, especially for what we call the cases that are not convention refugee status, but were granted, right, the B status in a way under 7.3. But could you maybe just elaborate clearly the three criteria there, in which way you feel that they differ and really have lowered that, and what your reflections you have on this lowering threshold that seems to have introduced also that uncertainty and the ability of a government in a way to start, you can say, working on more restrictive policies by zooming in on what they will say is a non-convention refugee status refugees. Over to you, Jens, if you could answer and add a few questions on that criteria. Thanks.
Thank you, Henrik. As you know, cessation of refugee status under Article 1C, 5 or 6 of the Refugee Convention is generally understood to require that the change of circumstances in the country origin has been or is fundamental, stable and durable. These cessation criteria have been sort of imported or included in the Danish revocation criteria, because formally we revoke residence permits rather than we apply cessation rules, but it's more or less the same in Danish law. And that interpretation of the revocation rules has been applied both to convention refugees' residence permits and to those of refugees with subsidiary protection. There have been attempts by the legislature to introduce a distinction here, I think since 2010, but it was not an explicit and not an unambiguous attempt by the legislature, and whether it was considered unclear or not relevant at all, or whether it was considered impracticable, I can't tell. But the fact was that the Refugee Appeals Board still applied these convention-based or convention-inspired cessation criteria also for those having subsidiary protection. And that was then brought to an end with the legislation in 2015 that introduced at the same time the temporary protection status. The legislature was not very truthful in stating that this was just a clarification. In fact, it was not a clarification, but it was a significant change as compared to all previous revocation cases in the Refugee Appeals Board. But at least by then, the Refugee Appeals Board understood the message and followed it very, very consistently. So that was sort of the way in which it all happened, and what we have seen now as being implemented towards first Somali refugees who had a kind of prima facie subsidiary protection status since the Sophie Elmer judgment in 2011, and who were then subjected to review of protection since I think 2016. That is long before actually the formal or official paradigm shift. But we saw some revocations of Somalis' residence permits already in 2016-17.
It's almost accepting risks, which is very different from the cessation clauses that Jessica also referred to in 1.5, which almost says that the risk should really have been removed fundamentally and durably. The threshold under 7.3, as you say now, to remove that or revoke that retains a lot of uncertainty and fragility. I have Anja Kluk who would like to ask a question. I think we have allowed your mic and video camera on. So Anja, if you can come in now, that would be a pleasure. Great to see you, Anja. Go ahead.
Thank you, Henrik, and thank you for inviting me. And it's really nice to see Jens because it's ages ago since I last saw him. So very nice. I was not aware of these developments in this dramatic outreach. So I mean, I'm very happy to have this perspective. I have a question, and if you're interested in Switzerland, I can also give you, of course, the Swiss perspective, because I assume that most people, even though if status is withdrawn, will still stay because they cannot be deported. I mean, I think you even referred to this in your presentations. But what does it mean then? Is there any assessment? What does it mean for people if they stay in a society, in a country, for long periods of time without any status? Can it lead to radicalization? Are there any sort of arguments that can be made from this angle? So I mean, it's not a legal question I have, but more, seeing what kind of arguments can be used against that practice. And secondly, I haven't seen any case law, ECHR, and I mean Sweden might also be, European Court of Justice. European EU is now the name has changed yet. Have you tried to bring cases in front of European Court of Human Rights or the ECJ or human rights bodies? Because we have also started using a lot, CART and CRC to address problematic practices in Switzerland.
Thanks, Anja. Your first question, would that be Jessica? Would you have some reflections on Anja's first question?
Sorry. Well, I think just to point out that no, we don't have research about this, but so far there hasn't. I mean, as you point out, there hasn't been a lot of actual returns as a consequence of the threat of cessation or actual cessation practice. And as I said, in the Norwegian context, the vast majority of cases that were opened ended up being set aside or decided on other grounds. So we don't see a connection between cessation and return as I guess the policies are premised on. So
No, my question is, and it's not a legal question at all. It's a question. It's a probably social, politic, or whatever. It's because we have also groups that have been, I mean, we have, for example, in Switzerland, Eritreans rejected, but they cannot be returned. Tibetans cannot be returned. So people live, on minimum social aid, in centers for extended periods of time. So what does this mean, for me, is there a danger, or could we argue that this brings dangers of radicalization, and especially, if this continues, to this next generation, what is happening to the next generation if your parents,
I get you, Anja. I think there's a big distinction here we have to have in view. Here we talk about recognized refugees whose status is revoked. And therefore, it's not about rejected asylum seekers in the first instance. That's a very important, significant change in a way, right? Because we talk about under what circumstance can you do and what then happens. Especially when you have a situation, as Jens also explained and Mahmoud also explained very well with his family, in fact, nobody can be returned. But actually the decision to return stands. The decision from the appeals board is final. There is no, so in that sense, it only hinges on the diplomatic relations and the EU agreement of not to return Assad. If there was a change, let's say in 30 days, an agreement in Brussels that it was possible, in fact, there is, in my view, not a direct opportunity for that to contest that secondly. You mentioned European Court of Human Rights and so on, just to say that exactly because there is no imminent risk of return, the accelerated procedure has not been possible to invoke. Yes, you can probably try to put forward a case that there was a final decision, but as there's no risk, you cannot accelerate that. So that's why there is not an immediate jurisprudence on that. So thanks for your question, Anja, and thanks also for having helped. And please keep a lookout on Syrian from Denmark, just as Mark is doing, and let's have an exchange with those. I see hands coming up from Jens, who probably wants to add a comment on what you just said. Jens, please come in.
Thank you, and thanks to you, Anja, for raising these issues. Beyond law, I agree fully with you that there is a risk of bringing quite numerous people in a very unsecure, marginalized position. I don't want to speculate what could happen to these people, but I agree with you that there is a risk of radicalization. Following discussions with Jessica, I ended up in the temporary report on Denmark, also more generally talking about systematically sort of moving people into irregular positions. That may happen within Denmark, where some go to these deportation centers, some do not. Some may go on living, trying to go under the radar here. And we have the problem about which Mark was speaking. We don't know how many of those moving to neighboring countries actually sort of pop up as asylum seekers, as those Mark was reporting, and how many may just be trying to go under the radar there as well. So it is bringing people into a kind of clandestine situation. And it also, the fact that people are losing protection but not deported, I agree fully with him, like that it's a different situation from that of sort of initial asylum seekers, but there's similar results here. We are having a situation of not even tolerated status, but just non-enforced negative decisions. And normally politicians would say that this is sort of breaking down the integrity of the asylum system, right? So I think that should be a factor in itself, and it also has some legal implications. First, that as far as I understand, the European Court of Human Rights has, at least in one case, simply refused to examine a Danish case in which the protection had been revoked, because, as the court said, deportation is not imminent, and therefore the case was premature, which put the Danish authorities in a kind of ideal situation. They can continue for domestic purposes to have restrictive practices, but they don't account for them, neither in domestic court probably, and certainly not in the European Human Rights Court. Secondly, this also in turn will mean that for an unknown number, probably many of these people, it will become relevant to reopen the cases if once there will be a deportation option. Then they may have revocation cases decided years ago, which will probably not be enforceable without a renewed examination by the appeals board. So I think it is a very sort of problematic situation, creating a kind of limbo, both for authorities and the protection or former protection holders.
Well, thanks, Jens, for those additional comments. I appreciate that. Letitia has asked us a question. I think she's asked our colleague Marie to read it out, or to just, can you give voice to that, Marie, please?
Yes. So Letitia Shaheen asks, if Denmark were to make a statement towards the current change in its strict immigration laws following the new government and the paradigm shift you mentioned in today's webinar, what would you think they should mention in their speech? And how do you think they should respond to the claims about the reality of Syrian refugees today in Denmark?
So, if I understand the question, I think, Mahmoud, if you are listening in here still and you can join us, in a way, it could be a question to you to reflect what should the new government's policy be if it was adopted. I think the one who asked the questions is indicating there may be a shift, as we indicated, as Jens also indicated. But Mahmoud, what would you like to hear if you saw the question, you heard the question? Do you have some suggestions for how you would see that?
Well, what I have heard from the new government that they want to make some rules so the young women who are, for example, education to be a doctor or something, so that society needs them, so they will have the right to get a residence permit. But it's not that the fact that all the Syrian refugees will feel safe and have the right to be in Denmark. So it's only those who are usable for the Danish society.
It's a very good answer, Mahmoud. Thank you very much for doing that. I would say it's a very utilitarian approach. If the revocation criteria already is the problem, you don't fix it by identifying who you then want to fish and protect. I think you have fully indicated that in the way the real problem is the revocation criteria, and the real problem is the lack of European consensus. When we had temporary protection from those of us who remember those days for Yugoslavians in Europe, there was a very strong European consensus approach with constant concerted consultations so that no one was jumping off the wagon in time. Here, what we are seeing, of course, is that there's a risk of a race to the bottom where one country decides to terminate. Just as you say, Mahmoud, this is not a common policy across all the European countries. And that is why Mark now in Holland sits with refugees who are saying, I still have a claim. And if I had turned left and gone to Amsterdam in terms of going straight on to Copenhagen, my life is completely different. How can that be in a European reflection on European governance? So Jessica, over to you. That's going to be your challenge for the European governance issue, because that is a challenge, isn't it, about how European countries and states try to manage that. That is a question mark of trust, as you also mentioned, between interstates. Another question is coming in, I believe, from Enyo. I don't know whether Enyo wants to speak it. It's put on the chat. Enyo, has the mic been enabled? Or otherwise, it's in the chat if you want to, but you want to speak quickly to what he's asking you?
Yeah, thanks, Enyo. So the question is essentially around whether the paradigm shift created change on the reception side for asylum seekers, as we've seen increasing problems in the Netherlands and Belgium. And I think the quick answer to this is no. I mean, the paradigm shift is not a reception issue; it's an integration issue. So the problems we've seen is, Syrian refugees have been here 6, 7, 8 years, embarking on education, employed in Denmark, having their integration severely disrupted. Now, the impact on the reception side, of course, is perhaps going back to what Jens mentioned, and that is the deterrence elements here, that the Danish paradigm shifts, I think quite explicitly, is designed to decrease Denmark as an attractive asylum state. And therefore, perhaps there's a sort of perverse success at play here where we see asylum levels in Denmark remaining fairly low. We don't see significant problems around reception of asylum seekers. Specifically, what we see is disruption of integration of refugees. Over.
Thank you. Thank you, Nick, for that. A question from Maya. I think her mic has been enabled and video.
Hello.
Yes, Maya?
Hello, good afternoon. Can you hear me?
Yes, we can. Go ahead.
Yes, I would like to ask, how do they qualify some place or city as safe for someone from that country, and how can they make sure that this particular city or place or region is safe for this particular person if he or she wasn't a convention refugee, in the meaning that they are like in the case of mass influx, you know? So
Yeah.
how can you know, in the case of Syrian refugees, I'm not pretty sure how they just like, you know, executed the RSD you know, procedure. So how do they know that this city is safe for this particular person? And especially if they have, for example, from the same families, for example, some people who are not, you know, who cannot go back home. So
And thank you. Thank you, Maya. Your question is very clear. Jens, you have followed some of the jurisprudence in the first instance and appeals board, and the question is very simple in a way. Damascus being considered safe, what does it really mean, and how is that standard applied? Do you want to just speak to that very quickly?
I haven't followed all details of the Refugee Appeals Board's jurisprudence on these cases, but it's well known that that there have been sort of disputed and inconsistent approaches to the issue of individual risk for certain profiles, in particular those who are relatives to people in the military age, which could be the situation about which Mahmoud was also speaking a few minutes ago. There have simply been different assessments on that by the Refugee Appeals Board, and some of the assessments, I mean, practices have been inconsistent, I think, and some of them have been incompatible with quite solid evidence from international sources. More generally, I think the question is, to which Maya is alluding, is simply whether it makes sense to make sharp distinctions between generalized risks and individualized risks. That, I think, is often a kind of that's often a kind of illusion, and it may actually end up in drawing false conclusions, I'm afraid.
Thank you, Jens. And indeed, I think what you're mentioning is very often that when there is a choice of status, when an asylum seeker arrives, in a way is satisfied to get protection, only to realize that the protection I got, if I had, you know, considered that more, I may have had a different standard. And the Refugee Appeals Board, of course, has also overturned a number of the 7.3, so the generalized violence, to individual persecution elements. So in a way, realizing on appeal of the revocation that actually the status should have been higher from the beginning. So it also shows some questions about the uncertainty of what level of status is provided. Thanks so much for that question, Maya. I hope that answered it. Jean-Paul Brecke, calling in from Geneva, I guess. Jean-Paul, over to you. I think your mic has been enabled.
Yes, sir. Thank you so much from Geneva. Just a few reflections here. The first one, I mean, we have documented the immense humanitarian costs and individual costs and costs with regard to integration of these new temporary arrangements. But listening to what's been said, I would like to zoom out and see it from the system side. Nick mentioned deterrence. And that is, of course, a major mechanism here, but it's a blunt political instrument, and I don't think the politicians really know what they're doing, but they feel like they have to signal control to their electorate and other stakeholders. And the costs are immense, and I think they actually are willing to take these costs, not only on individual level, but also to the bureaucracy and civil servants. If you interview civil servants about this is a nightmare because it's very, you know, and they see the limited output from this. But my last reflection here is just on the immense pressure these systems put on the instrument of return. And the people working with return, we know that this is one of the most challenging things that the bureaucrats and operational agents in Europe do. And it's not working very well for anyone involved. And now the pressure becomes immense. So it's very optimistic, I would say, from a systems perspective. that they expect the return element side of this to actually be working. But I think, again, I think it's okay for the politicians as long as it looks like things are working and it's the signaling is right and the messaging is right. They are willing to take these costs at all these different levels, also in the field of integration, which is very unfortunate long term. Thank you.
Thanks for that observation, which was more a comment, I think, and
Yes.
also a reflection on the power game in terms of how governments in their wins of showing the electorate that they are in control of migration tries to find one of the areas which is, I wouldn't say a field, where there seems to be more leave room for more rough approaches. Mark, I have a question for you, because I think it's of interest to many of the Danish civil society organizations, because indeed, with the Syrian, no European country has actually stepped up with a voice about what's happening in Denmark. They're all keeping silent. There has been some queries from out of seas, from Canada and others, who have questioned the human rights situation on Syrians, but none, European country has really questioned Denmark on what's going on, which in itself is a signal. So in Holland and in the court cases, I think many are looking for some statement that Denmark is considered unsafe for Syrian refugees almost, some kind of assessment, not just on a technicality, not just on a time period, but a stronger issue about exactly the question you raised, the state's interest and trust. Could you elaborate a bit on what you saw in that one decision you saw? And if you also could keep some of us posted if you see more along those lines, I think that would be a great interest to a lot of the advocates here in Denmark. Over to you, Mark.
I would say that such a statement is definitely not going to be made by the Dutch government, because it will be how do you call it, Dutch, a motion of distrust. It would be quite defamatory for the Danish state, and they are together in the European Union, and there is the principle of interstate trust. So the Dutch state, the immigration service, they may lose situations like this case by case, but they will never make an official statement that Denmark is not safe, because that will be, taking away the bottom beneath the European, the common European asylum system that we have in Europe. That it's just not going to happen. But there is in the Netherlands a system of judicial review that, thanks to several circumstances at this moment, has quite a lot of attention for individual cases and for the risks that people run. So I do think that people in the Netherlands might be rather safe, especially Syrians, from being sent back via the Dublin regulation to Denmark. But I don't see the Netherlands making an official statement that Denmark is not a safe country, not at all. And
we wouldn't expect the government to make it, but I'm wondering what the legal rationale was for the legal decision that you referred to. If I understood correctly, that there was a Syrian from Denmark who had a chance to stay in Holland. So what was a court's rationale for that?
The court's rationale was that there was a risk of refoulement, of sending my client back to Syria from Denmark, and that my client has proved that risk is so high that it was up to the government to dispel any doubt that she might be returned to Syria. And as long as they cannot dispel any doubt about that, there is still a real risk of a treatment in violation of Article 3 of the European Convention, and she cannot be sent back. And that, I do think, that will go for every Syrian national that comes to the Netherlands via Denmark.
Thanks, Mark, to hear that. And you can then say that while I was understanding the Prime Minister would not say it, it seems like a judge has said what I was just saying, almost, that indeed, because of that. You see what I mean? And that is in a way also valuable. So interesting to understand, because it is about also interstate management and legal management in that sense. Jens, you want to come in with a reflection? And then
just,
we need to wrap up shortly.
Just a brief observation. If I'm not mistaken, when the Danish immigration minister visited the European Parliament exactly a year ago, he was criticized, I think, not only for the plans to transfer asylum seekers overseas, but also for the practices concerning Syrian ex-refugees, relocation practices. And my second remark would rather be maybe a question to you, Mark. As you mentioned, there are cases pending before the European Court of the EU Court of Justice. I checked just this morning that the 3 Italian cases from tribunals in Milan, Florence, and Rome have not yet been decided as to whether risk of indirect refoulement can or has to be taken into account in Dublin transfers. So one may speculate that there may be an unknown number of cases suspended in domestic courts in various member states, awaiting this the clarification, the answers from the EU Court of Justice in these 3 preliminary rulings.
That is definitely possible. It was asked to the Court of State in the procedures about the Syrians in the Netherlands, and it was refused by the Court of State because it considered the legal questions at hand too simple to find it necessary to wait until the Court of Justice has decided.
I think our time is up. I wish to thank, first of all the participants who volunteered to join us today. I hope you found it useful and of relevance, and there are resources on the net. I hope this sparks a discussion, sparks some further reflections in your respective countries, and the chat function now remains open, as you know, so those of you who want to do that is possible. I wish to thank all the panelists, Jens, Nick as co-organizer here, thank you so much for co-hosting this together. Jessica, Mahmoud specifically, of course, for having joined us and giving that, and also for Mark from Holland to have given us that. Thank you so much, Mark, for attending, all of you.
Thanks
and
for having me.
wishing you all a good continuation. And Mahmoud, let's hope for some good future, peace in Syria, resolution of conflicts, but also in the meantime, some solutions in Denmark for the Syrian refugee community. Thank you so much all for joining. Bye-bye.
Thank you.